I want you to think about your house in a way most people never think about it, not as a memory, not as the place where you raised your children, not as the safe asset you worked 30 or 40 years to own. Think about it as a line on a state balance sheet. That is the way the system will look at it. If you ever need long-term nursing home care, and that is why the Medicaid 5-year look back is one of the most misunderstood rules in American retirement. The name sounds harmless. It sounds as if someone is simply checking records. But systems often hide their real force behind soft language. The rule is not merely a look back. It is a mechanism that can punish a senior for transfers made years earlier, at a time when that person had no idea they were creating a future problem. If you are 65 or older, if you own a home, if you have savings, if you have adult children, or if you believe your house will automatically pass safely to your family, you need to understand this rule before the need for care appears. Because once the need appears, time stops being your friend. Long-term care is expensive. The average nursing home stay now costs over $108,000 a year. That is not a normal bill. That is not a bill most families can simply absorb. It is a bill large enough to consume savings, retirement accounts, home equity, and family plans that took decades to build. When people run out of money, they commonly apply for Medicaid to cover nursing home costs. That is where the rule begins. Before Medicaid pays, a state caseworker can examine the previous 60 months of your financial life. Bank statements, property records, transfers, checks, gifts, cars signed over, money moved between relatives. The system does not look at these transactions the way a family looks at them. A family says, "I helped my granddaughter." The system says, "Transfer." A family says, "I helped my son repair a car." The system says, "Transfer." A family says, "I sold the old car to my nephew for $1 because he needed transportation." The system says, "Transfer for less than fair market value," and then the system calculates a penalty. This penalty is not a fine in the normal sense. It does not simply take a fixed amount and end the matter. It creates a period of time when Medicaid will not pay for your care. The state takes the total value of the transfers made during the look-back period and divides that number by a regional penalty divisor. In many states, that divisor sits roughly between $10,000 and $12,000. The result is the number of months you are locked out of Medicaid coverage. That is where the trap becomes severe. You apply for Medicaid because you do not have the money to pay for the nursing home. But if the state says you transferred assets during the look-back period, it may refuse to pay for a calculated period. So you gave away money and therefore cannot pay. But because you gave away money, the state will not pay either. That is a dangerous system design. The nursing home still expects payment. The bill continues to run. The facility does not care that the family misunderstood the rules. It does not care that the gift was made at Christmas. It does not care that nobody explained the difference between tax law and Medicaid law if the bill is not paid. The nursing home can pursue collection, and the most obvious asset in the family is the house. This is where many seniors make the first critical mistake. They believe only large transfers matter. They believe the rule is designed to catch rich people hiding mansions and big bank accounts. But that is not how these systems usually work. Once a rule exists, it applies according to its mechanics. A $400 Christmas check to a granddaughter can count. Money for a son's wedding can count. College tuition support can count. Forgiving a family loan can count. Selling a car to a relative for $1 can count. Even charitable donations over certain thresholds can matter, depending on the state. There is no holiday exception. There is no birthday exception. There is no exemption for the fact that you were trying to be kind. There is no protection based on not knowing. And one of the most common sources of confusion is the federal annual gift tax exclusion. Many families hear that they can give a certain amount each year without triggering federal gift tax concerns. They assume that means the gift is safe for every purpose. That assumption is wrong. The gift tax system and the Medicaid system are separate systems. What the IRS allows is not the same as what Medicaid will ignore. A gift can be perfectly legal under federal tax law and still create a Medicaid penalty. That is the kind of distinction that destroys people because it sounds technical. But the consequences are practical. The practical consequence is months without coverage, while a nursing home bill grows at roughly $9,000 a month or more. When you study systems, one of the most important things to understand is that people often fail not because they are bad people, but because they are operating with the wrong map. They think they are playing one game. The system is playing another. The family thinks the game is kindness, taxes, and inheritance. Medicaid is running a resource eligibility system. The nursing home is running a billing system. The state is running a recovery system. Those systems can collide at the exact moment a family is least prepared to think clearly. That is why this must be understood before the crisis. Now let us look at the second false assumption. People believe that if one spouse goes into a nursing home, the healthy spouse who stays at home will be fully protected. There is some protection. It is called the Community Spouse Resource Allowance. In 2026, that maximum amount is $157,920. That is the amount of countable assets the at-home spouse may be allowed to keep. Everything above that must generally be spent down before Medicaid pays. On paper, $157.09 the 20th of May sound meaningful, but numbers must always be translated into lived reality. That money may need to cover property taxes, home repairs, Medicare premiums, food, gas, medications, emergencies, a roof, a furnace, a car problem. And it may need to do that for the rest of the healthy spouse's life. If that life lasts 20 years, the number that looked large becomes very small when divided across time. That is how systems create false comfort. They show a big number, but life spends in small repeated withdrawals. A surviving spouse does not live on a headline number. A surviving spouse lives month by month, and while that person is trying to live, the nursing home can be billing over $9,000 a month for the other spouse. That is why families who think they are protected sometimes discover they are protected only in a narrow legal sense, not in a practical economic sense. Now we come to the house. The house is the emotional center of the story. Most people believe the house is safe. They believe Medicaid will not touch it, and there is a partial truth inside that belief. While the Medicaid recipient is alive, and while the home is being used as the primary residence, the house may be treated as exempt for eligibility purposes. That means Medicaid may not force a sale before benefits are approved. But that is not the end of the system. It is only the first phase. After the Medicaid recipient dies, another process can begin. It is called the Medicaid Estate Recovery Program. Federal law requires states to attempt to recover the cost of care from the estate of a Medicaid beneficiary who was over 55 when benefits were paid. The target is often the house. The state files a claim against the estate. The heirs are told they must either pay the bill or sell the home and turn over proceeds. The average estate recovery claim now exceeds $74,000. In some states, it can exceed $200,000. This is where the language of safety misleads people. The house may be safe while the person is alive, but it may not be safe for the heirs. It may not be safe as an inheritance. It may not be safe as the family asset everybody assumed would pass to the next generation. The system can wait, and when the person dies, the claim can arrive. I want you to understand the causal chain. A senior needs care. Care costs more than savings can support. The senior applies for Medicaid. Medicaid examines the prior 60 months. Transfers can trigger a penalty. The nursing home bill continues. If Medicaid later pays, the state may pursue estate recovery after death. The home becomes the recovery asset. The children who thought they were inheriting security may instead inherit a demand letter. That is the system. It does not require cruelty from any individual person. It only requires rules interacting mechanically. And rules interacting mechanically can be more dangerous than obvious malice because people do not see them coming. There is another layer that many families never consider. In 29 states, including Pennsylvania, North Carolina, New Jersey, Connecticut, and Georgia, there are laws often called filial responsibility laws. These laws can allow adult children to be held financially responsible for unpaid nursing home bills of their parents. For many years, these laws were not used often. But once a Pennsylvania appeals court ruled in 2012 that a nursing home could collect $93,000 from an adult son for his mother's care, the possibility became harder to ignore. So the risk is not only that the state can come after the house. The risk is also that a nursing home may pursue the adult children for unpaid amounts. This is what makes the problem intergenerational. The parent thinks, I am only affecting myself. The system says, no, this can affect the estate, the house, and potentially the children. When you look at wealth transfer, this is one of the places where families lose the game without realizing the game has begun. It is not always because they spent foolishly. It is not always because they invested badly. Sometimes they lose because they failed to position the assets before the rule's clock started to matter. Consider the example of a widow in Ohio. She is 78 years old. Over a 4-year period, she transfers $45,000 to her daughter. Some of it is birthday money. Some of it is holiday checks. Some of it is help with a car repair. From the family's perspective, this is normal. This is what parents and children do. It does not look like estate planning. It does not look like a Medicaid strategy. It looks like family. Then she enters a nursing home in month 47. The state reviews the previous transfers. The total is $45,000. The penalty divisor in that example is $7,463 per month. That creates about a 6-month Medicaid lockout. The nursing home bill is $9,200 per month over 6 months. That is $55,200. She does not have it. The facility places a lien against the house. She dies 8 months later. Then the state files an estate recovery claim for an additional $140,000 in care costs. The daughter receives notice that the home she grew up in is being sold by court order. Notice the pattern. No one in that story needed to be reckless. No one needed to be greedy. No one needed to be hiding assets in a dramatic way. They only needed to misunderstand how ordinary family transfers interact with the look-back period. That is why the 5-year rule is so dangerous. It turns normal family behavior into a future eligibility problem. Now, there are late-stage strategies some attorneys use when a family has already waited too long. One is often called the half-a-loaf strategy. The idea is that if care is already needed, the family may transfer part of the assets and use the remaining part to pay for care during the penalty period triggered by the transfer. That can save something. It may be better than losing everything, but it requires precise timing. It requires a specialized attorney, and it generally has to be done before the Medicaid application is filed. Once the application is filed, the opportunity may be gone. This is a key principle. A strategy that works before the system is activated can fail after the system is activated. Timing is not a detail. Timing is the strategy. Most of the seniors who lose everything are not the people who planned early and made a deliberate choice. They are the people who were never told that planning was an option. They sit in a hospital room. They sign a power of attorney. They begin writing checks to a facility. They are tired. Their children are scared. Everybody is reacting. And in that state of reaction, the system has the advantage. The difference between protection and loss may have been one phone call 2 years earlier or 5 years earlier, or one conversation with the right kind of attorney before the crisis arrived. That brings us to the document most people never ask about because they do not know its name. It is called a Medicaid Asset Protection Trust. The phrase matters. You cannot assume every estate planning attorney will bring it up automatically. A senior walks into an attorney's office and asks for a will. A will is simple. A will is familiar. A will may cost a few $100s. So the attorney may prepare a will, but a will does not solve the Medicaid look-back problem. A will does not stop estate recovery. A will does not start the 5-year clock. A Medicaid Asset Protection Trust is different. It is an irrevocable trust. Assets are moved into the trust that can include the house savings and investments. Once properly transferred, you no longer technically own those assets in the same way. The trust owns them, but you may still be able to live in the house. You may still be able to receive income from investments. What you cannot do is simply take the assets back as if nothing changed. That is the trade-off. Protection requires giving up certain control. After the trust has been in place and funded for 5 years, the assets inside may no longer be counted by Medicaid. The look-back period cannot reach back beyond that 5-year clock. Estate recovery may not be able to reach those assets because they are no longer passing through the estate in the same way the house can pass to heirs without being exposed to the same probate and recovery process. That is why the funding date matters. Not the day you think about planning, not the day you call the lawyer, not the day the documents are drafted, the day the assets actually move into the trust. That is when the 5-year clock starts. In 5 specific states, including Florida, Texas, Michigan, West Virginia, and Vermont. There is also a tool called a Lady Bird deed that can accomplish part of the goal for the home specifically. It is not the same as a full Medicaid Asset Protection Trust. It is narrower, but in those states, it can matter enough that a homeowner should ask about it by name. The reason most families do not use these tools is not always cost. A Medicaid Asset Protection Trust can cost between $4,000 and $12,000 to set up correctly. That is not small. But compared with a nursing home bill of over $108,000 a year, or an estate recovery claim of $74,000 or $200,000, the cost must be compared to the risk it is designed to reduce. The deeper reason people do not use it is that nobody tells them the system in time. They hear about wills, they hear about probate, they hear about powers of attorney, but they do not hear about Medicaid planning until a hospital discharge planner starts asking where the patient will go next. By then, the time advantage has already been lost. This is one of the most important principles in decision. Making the best time to solve a predictable problem is before it becomes urgent. Once it is urgent, every option becomes more expensive, more constrained, and more emotional. The 5-year look-back rule is designed around time, so the only rational response is also designed around time you have to start before you need it. This week, the first thing I would do is reconstruct the last 60 months, not from memory. Memory is not good enough. Pull the actual bank statements. Look for transfers over $500 to family members. Make a list. The goal is not to panic. The goal is to know your exposure. A person who does not know the facts cannot make a good decision. Second, I would find an attorney who practices elder law specifically, not just a general estate attorney. The certification to look for is CELA, which means Certified Elder Law Attorney. This matters because Medicaid planning is its own system. An attorney who writes wills all day may not be the person who sees the Medicaid trap clearly. You need someone whose practice is built around long-term care planning, Medicaid eligibility, asset protection, and the way state rules interact with family assets. Third, I would ask the attorney directly about a Medicaid asset protection trust. Say the word. Do not wait for the attorney to choose the topic. Ask whether you qualify. Ask what assets should and should not be moved. Ask how the 5-year clock works in your state. Ask what happens if care is needed before the clock ends. Ask how income is treated. Ask how the home is treated. Ask what estate recovery can and cannot reach. Fourth, if you live in Florida, Texas, Michigan, West Virginia, or Vermont, I would also ask about a Lady Bird deed for the home. Again, say the words. Do not assume the topic will appear by itself. Fifth, if a trust is the right structure, I would not let the documents sit unsigned or unfunded. An unfunded trust is not protection. It is paper. The clock starts when the assets move. That is why the most expensive day can be the day after you should have started. One day feels small, but one day delayed is one day added to the back end of the 5-year clock. And when a health crisis appears, the family does not need almost 5 years. They need the clock to already be completed. This is not a story about avoiding responsibility. It is not a story about hiding money improperly. It is a story about understanding the rules of a system before the system uses those rules against you. If the law allows a structure, then using the structure is not manipulation. It is planning. The wealthy understand this. Institutions understand this. People who preserve wealth across generations understand this. The middle class often does not, because it is taught to be responsible but not always taught to be strategic. Responsibility says pay the bill. Strategy says understand the system before the bill arrives. Responsibility says help your family when they need help. Strategy says know whether a gift today creates a penalty tomorrow. Responsibility says make a will. Strategy says ask whether a will is enough. Responsibility says the house is paid off, so it is safe. Strategy says safe from what and safe when and safe for whom. That is how I want you to think. Not emotionally, not politically, not with panic, with cause and effect. A 5-year look back creates a 5-year planning window. A transfer creates a possible penalty. A nursing home bill creates pressure. Medicaid eligibility creates review. Medicaid payment creates a state recovery risk. A funded trust starts a clock. A completed clock changes what the system can reach. That is the chain. Once you see the chain, you can stop thinking of this as a surprise and start thinking of it as a risk that can be managed. The worst outcome is not that the rule exists. The worst outcome is that families find out only after the window has closed. They find out after the care is needed. They find out after the transfers have been made. They find out after the Medicaid application has been filed. They find out after the house has become the recovery target. They find out after the children are holding a letter from the state or a nursing home. That is too late. The point is not to become afraid of every family gift. The point is to stop making blind moves inside a rule-based system. If you are healthy now, that is the moment to plan. If your parents are healthy now, that is the moment to have the conversation. If the house is still owned directly, that is the moment to ask whether it should remain that way. If the family assumes everything will pass smoothly, that is the moment to test the assumption. Do not wait for a crisis to reveal the rule. Rules do not become kinder because you learn them late. They do not pause because the family is grieving. They do not ignore 5 years of statements because the gifts were made with love. They operate, and because they operate, the only intelligent response is to prepare before they operate on you. The 5-year rule is not really about the past. It is about whether you had the foresight to make the past work in your favor. 5 years from now, you will either be glad the clock is already running, or you will wish you had started it today. That is the decision. Not whether you like the rule, not whether the rule feels fair, not whether your family deserves to keep the house. The system does not make decisions based on what feels fair. It makes decisions based on eligibility, records, transfers, dates, and ownership. So the question is simple. When the system looks at your records, what will it see? Will it see unplanned transfers, direct ownership, and a house exposed to estate recovery? Or will it see a family that understood the rules early enough to structure things before the crisis? That is the difference between preserving a home and losing one. That is the difference between inheritance and recovery. That is the difference between reacting and planning. And in systems like this, planning is not optional. Planning is the asset.